Lynne Stewart, in 2002, Lynne was indicted on support for terrorism charges. She's a longtime activist and human rights attorney in New York. She's represented criminal defendants for 31 years, effectively and beautifully and humanely. And she's an inspiration to many attorneys, you know, for me within the Guild, but also as the general legal population can look to Lynne for her zealous advocacy and her heart and soul that she pours into her clients. So in May of 2000, Lynne was involved in the representation of one of her clients, Sheikh Omar Abdel Rahman, who was convicted in 1995 of I'm sorry, what was it?
Conspiracy to blow up New York landmarks. It's hard to say those things, no.
Thank you. So she represented him in his trial and his subsequent appeals, along with another attorney, Ramsey Clark, who was the former Attorney General. Her subsequent representation to the trial and the appeals included litigating the Sheikh's prison conditions. He was in prolonged isolation. He was denied medical treatment, and there was restrictions placed on his practice of religion. He was blind and diabetic as well, and he was suffering greatly in his isolated state. In 1997, special administrative measures had been imposed on the Sheikh. These measures prohibited him from communicating with anybody besides his lawyers and specific family members. And the purpose of these special administrative measures was to prevent future acts of terrorism. The lawyers and his lawyers had to sign affirmations that they would abide by the SAMs in order to continue to visit with their client. And normally when these special administrative measures had been violated, the attorneys were prohibited from seeing their client for a certain amount of time. There were no criminal repercussions. It was an administrative measure. The lawyers in this case had limited access to the Sheikh, and their visits were infrequent. They took turns communicating with him, keeping him abreast of world events, and communicating information to and from third parties in Egypt and the US. Many religious followers of the Sheikh sought his advice on a wide range of matters. The lawyers believed that they were permitted to engage in these communications because the special administrative measures permitted lawyers to engage in legal matters. And in advocating for her client and trying to get him to have better conditions, Lynne believed she was effectively advocating for him by keeping him in the public eye. The goal at this time in 2000 was an attempt to transfer the Sheikh to Egypt, where he could be closer to his family and where he would be in more familiar surroundings. To effectuate this transfer, they considered it very important to keep him in the public eye. So the events that led to her indictment occurred in May of 2000 and June of 2001. Lynne and her interpreter, Mohammed Yusri, made 5 visits to the Sheikh, 2 of which formed the basis for the indictment. 2 of these visits were videotaped pursuant to the Foreign Intelligence Surveillance Act warrant. And these communications were between an attorney and a client and should have been protected by the attorney-client privilege. During one of these visits in May, Yusri read a letter asking the Sheikh for his view on a 3-year-old ceasefire in Egypt. The Sheikh dictated a letter to Yusri stating that he withdrew his personal support for the ceasefire and that the Islamic group should engage in discussion on whether they should resume media criticism of the Mubarak regime, of the very oppressive regime in Egypt. After several weeks of considering whether she should issue this statement, this press release, Lynne decided to do so, believing that this was a way to effectively advocate for her client. She believed it was part of her role and did not intend it or believe it was a call for violence or would lead to violence. And this is very important because the basis of the charges against her is that her intent was to contribute to acts of terrorism. As I said, she knew it was important to keep her client in the public eye in order to transfer him to Egypt. And this was part of their plan, and then September 11th happened. And that's basically when things went downhill for a lot of people in this country and around the world. So going back, so in June, Lynne Stewart called a Reuters reporter in Cairo, Egypt, and read the statement of the ceasefire, that Sheikh Rahman was withdrawing his support for the ceasefire. Several days later, she issued a clarification stating that the Sheikh was withdrawing his personal support for the peace initiative, but that the matter was up to the Islamic group. Further discussion did occur, but no violence ensued. In August of 2000, a few months later, Patrick Fitzgerald, who was the U.S. Attorney General who prosecuted the Sheikh, called Stewart and told her that she would be cut off from her client and would have to renegotiate the conditions under which her visits could resume. Stewart's lawyer followed up with Fitzpatrick and spent 9 months renegotiating the terms of the special administrative measures. She was then allowed to visit her client again. And then 9/11 occurred. So you have to, picturing it in the context of the time, this was pre-9/11, she had issued a statement, violation of the special administrative measures, believing that no acts would come from that, no violence acts would come for that, nor were none intended. Post 9/11, new administrations in office, there's a war on terror, they need convictions, and they need convictions of terrorists. They can't get those convictions, so they start widening that definition. They start to include actions they look back to before 9/11. And then, so in April 2002, 2 years after her original press release, John Ashcroft announced Lynne's indictment on appearance on the David Letterman show. Yeah, serious. The judge threw out these first charges because the law under which she was first indicted was unconstitutional, but that didn't stop the government. They found another law and reissued the indictment. And that is the second indictment, and the second subsequent trial is what led to her conviction. So basically, Ms. Stewart violated violated the special administrative measures, but it was not a crime to violate these measures, nor was it at the time that she did so. She was aware that taking this action, issuing this press release, might cause her to be barred from seeing her client, which is what happened and which is what usually happens. The government, however, decided to go full court and, as I said, prosecute people for terrorism by widening the net of what that definition means. And they used Lynne as an example to other advocates in order to discourage them from providing zealous advocacy to unpopular clients. So because Lynne didn't have the necessary clear-cut intent for what they were charging her with, the government took to McCarthy-era tactics and guilt by association and putting on a whole show for her trial. She was put on trial with Mohammed Yusri, her translator, and Ahmad Sattar, her legal assistant. The administration decided they would use their full resources to secure this conviction. 75% of the evidence was against Sattar. Unbeknownst to Lynne or her translator, Sattar was in contact with militant members of the Islamist group in Afghanistan, London, and Iran, and had issued a false fatwa in the name of Sheikh Rahman. No evidence was ever presented that Lynne Stewart or Mohammed Yusri knew about Sattar's activities. The evidence that the government did present contained volumes of wiretapped conversations between Sattar and these militants and were often filled with violence and anti-Semitism. They had no relation whatsoever to Lynne's case or Yusri's case, and they were highly prejudicial. Another point that I would like to point out is that in 1997, Ramsey Clark made a press statement announcing the Sheikh's support for the ceasefire between the Islamic group and the Egyptian government. At Lynne's trial, the U.S. Attorney Pat Fitzgerald testified that this was a violation of the SAMs. The government attorneys, in an attempt to distinguish Lynne's statement from Ramsey Clark's statement, said that Fitzgerald was mistaken that Clark had violated the SAMs. And the last and probably the most highly prejudicial thing that was shown at the trial was a videotape of Osama bin Laden expressing support for the Sheikh. And this was shown during the trial, shown to the jury in blocks away from the World Trade Center. And they were shown this video post 9/11 of a video taken pre 9/11, which there was no other purpose for that but to incite the members of the jury. And one final point I'd like to make is that several of the jurors wept when the verdict was read, which calls into question a lot about how they came to that decision. After her conviction and before her sentencing, over 1,000 people wrote letters to the sentencing judge, including members of the government. The government continued to press for a 30-year sentence for Lynne, 30 years, and they would not back down from that position. Thankfully, the judge issued a 28-month sentence for Lynne, and she's fighting her conviction, she's appealing her conviction, and we're hoping she's going to be victorious, and we're going to support her every way we can.
In my view, this really isn't about the case and me as much as it is about lawyering and what has become of lawyering over the last 5 years. It's almost 5 years since I was arrested. In April it will be. And my perception is, and I have been, we'll come back to how I have been criticized for this, is that we have seen a freezing of the playing field upon which lawyers operate. And this, of course, has to do with the sense that we have of who controls the court. I don't mean the basketball court, but I mean the courts, and who is in charge there, and who calls the shots, and who says what may be done and what may not be done. Even before I was arrested, there was a sense on the part, in certainly the federal judiciary, that the government had taken a bigger and bigger mouthful of what went on in court, that there was very little room for real lawyering. Everything was a plea. Everything was a cooperation. Everything had to be determined by the U.S. attorney, not by the attorney and the client figuring out, can we defend, can we not defend, but by what the U.S. attorney would offer, what the U.S. attorney would allow. And even judges felt that. A federal judge in New York retired and wrote an op-ed piece in the Times about how he felt his hands were tied, the jury's hands were tied, everybody's hands were tied, and it was only the government that controlled what happened in the criminal process. So into this, I get arrested 6 months after 9/11. I like to always tell the story. They came to my house in Brooklyn. You saw it on the DVD, a little house with a stoop, which I was sitting on. A stoop, if you don't know what it is where people in New York who don't go to Southampton spend the summer, sitting on the stoop, watching the neighborhood go by. At any rate, it was an April morning, and we were ready to get out to court. My husband Ralph and I, he had moved a little faster than I had that morning, a miraculous thing in and of itself, but he was already out on the stoop. And I heard him say, "Well, I don't see any badges." "Uh-oh," says I. "This is trouble." So I walked to the door and I looked out and I saw arraigned in my little front garden there 6 or 7 people, which I immediately knew were police. You can't do criminal defense work for 30 years and not be able to spot a cop. I don't know if it's the shoes or the polyester, what it is, but I knew they were police. And as I heard Ralph said, "I don't see a warrant either." I leaned over and I said, Ralph, take it easy. We'll have you out by lunchtime." He's the troublemaker, has been for 40 years. He gets arrested going to a PTA meeting to argue that the schools need to be changed and improved. I'm the lawyer. I didn't do anything wrong. Well, the FBI guy put his foot on the step and said, "We're not here for him, we're here for you." A moment of real definition in anyone's life, the FBI announcing they've come to arrest you. And of course, being a criminal defense lawyer, I know better than to say, "What for? I haven't done anything." Because I know how they use anything you say against you, no matter what it is. So I kept my mouth shut, and I'm thinking, what can this possibly be about? And your life sort of flows in front of your eyes. But I knew I had done nothing wrong. I'd been practicing law. I'd been defending people the way I always defended them. What could this possibly be about? And it wasn't until later that afternoon, after I went through the whole process, you know, the cuffs, the car, downtown, pictures, the whole arraignment works, that I saw the indictment and I realized what it was about, and it was basically about a lawyer making a press release on behalf of a highly political client whose voice deserved to be heard. At any rate, that's the origin of the case. And the case didn't stop there, of course. We then went through months of raising of issues, which will again be raised on appeal. We went through 9 months approximately of trial, a trial in which were actually mentioned Osama bin Laden. She didn't mention that the picture that they put up in that courtroom was as big as this screen, and basically paraded. And we later learned that there's a directive to the U.S. attorneys that if they're trying a T case, terrorism, they are to get Osama in there somehow, because he is the symbol for he's the visceral reaction of a jury. Oh my God, this is bad. And even though they put up the big picture and then the judge would intone, this evidence is not to be considered against Ms. Stewart or Mr. Usry. It is not offered for the truth. It is only offered for the state of mind of Mr. Sitar. Well, as one of the old timers once said, you know, you can't throw a skunk in the jury box and tell the jury not to smell it. It's there. It's part of the thing. You have a response to it. And of course, this jury, as I mentioned earlier today up at Lewis and Clark, they were mostly Manhattanites. They each had their own 9/11 story. These were people who were not 10 blocks from the World Trade Center. So of course they had a reaction. And of course the government pushed on that, just pumped on that, made sure that it was ratcheted up on every occasion. And in their final summations to the jury, they basically said, you know, you should trust us. We are going to make the world safe from terror. Something which we've heard a lot from this particular government, something that's not new to our ears, but really, I think, in that kind of a close quarters, made this jury afraid to do anything else. There also mentioned the tears in the jury box, but what we didn't mention was that one woman did come forward and said she actually was so intimidated, she feared for her life in the jury room. She was a black woman. She was from Harlem. She was not the most articulate of people. And she has since been interviewed. We have presented this interview to the judge. His basic answer to us was, she didn't come forward and tell me when it was happening. So therefore, I don't have to decide this. Whatever happened in the jury room happened there. We're not going to go outside that. Another issue for our appeal. With all of this comes the winter time. We're getting ready for sentencing. I have a fabulous team of lawyers working for me. Not one, not two, not three, not four, 5 lawyers working, to say nothing of myself, who still considers herself a lawyer even though I'm not, according to the official stuff, discussing how to go about this sentencing. And you know what collectivism is. I have a friend who said that the penalty of being on the left and being correct politically is endless meetings, which some of us know to be true. I also have friends that went underground in the 70s and said anything to get away from the contentious left, they said. So we had 5 lawyers, all with varying political credentials, all with different ideas of how to do this sentencing, what had to be done, what must be done, what should be said, how should we present it. But you know, I'm a great believer in collectivism, and that even with the wrangling and whatever, you come out with a great product. And so when we went in for sentencing on October 16th, after I had come through an operation for breast cancer, and we were ready for whatever happened that day. We left the house, Ralph and I had my medications in a little bag, and I had my book, and I had a sweatsuit to change into so that I wouldn't be in jail in a dress and stockings. And we really felt that this judge was not going to do us any favors. We knew we had submitted a phenomenal memorandum of law, and mostly we knew we had submitted over 1,100 letters to him to show the depth of feeling about this case. And I tell you right here, a lot of those letters, including the one from my brother, were postmarked Portland, Oregon, because we came out here and we asked you to write a letter. And we asked you not to just sign on a form, but to sit down and think why this case meant something. Even if you didn't know me, even if you didn't know my work, to just look at the case and tell this judge, we think, or I think, that this is not the direction we should be taking. And some of the letters, all were read by this judge. That's what he does. He's a reader. You would say, oh, you got 1,000 letters. I'm sure he didn't look at them. He read them. He's the kind of guy who reads the whole indictment before he'll come out and take an arraignment. So we knew he would read them. So we grouped these letters. We submitted 1,000 letters. We had others that we kept aside because we figured we didn't want to overwhelm him and they were somewhat repetitious, but they were all there for him to see and to weigh. And I really, you know, people say, well, are you happy with the result? You got 28 months? Well, you know, the government was pressing for 30. The probation department that writes the report, they wanted 30. Years. Oh, yes, years. 67 years old plus 30. You can do the math. They basically wanted to see me die in prison, and they still do, because they have appealed the sentence, which came out to be 28 months, and they are asking again for that 30 years. Sometimes, you know, you can never, you say, how could they do this? Why can't they just let it go now? The judge spoke, he spoke eloquently about why this was the right sentence. Why can't they? Because they're the government. This is how they are. This is how they operate. They are overreaching. They want more. And why do they want more? And I firmly believe they want more because they wanted to make an example of me to lawyers. To say to lawyers, you'd better not do what Lynne Stewart did. You better do what we tell you to do, or you too could get 30 years. And let's face it, we lawyers, we're the butt of many jokes, but the fact of the matter is that we have mortgages and kids in private school and loans that we took out in law school, and it's a consideration. It's not just easy to ride in there and say, I'm going to do the right thing and be damned. So it's a real heavy thing, and the day that I was convicted, they were training 100 lawyers to go to Guantanamo, and Michael Ratner, my friend from the New York Center for Constitutional Rights, told me that the minute they heard the verdict, that the jury had convicted me, these lawyers wanted to talk about nothing else but how they could avoid my fate, how they could avoid that happening to them. And of course, there's really only one answer. And that answer is to do what the government tells you. Now, that said, I've been accused of saying that I'm putting down the whole profession because I'm acting like there's not any lawyers out there that'll fight for the people. That when I say there's a chilling effect, I'm saying you can't get a lawyer to fight for you. Well, I don't believe that. I certainly don't mean to imply that. And I certainly would like to give you some good examples before I leave of lawyers that do fight for the people. But I want to say on the profession as a whole, there is a chilling effect. There is a sense of people not wanting to take a case of a Muslim. If they get a call from the clerk and says, I have a case, Mr. Muhammad's been arrested for money laundering. Call me next time, hon. I'm going to pass on this one. Or even worse, I'll take the case. What's the number for the assistant U.S. attorney handling it? And the first call is not to go to the jail and see the client and find out what the case is about. The first call is to the U.S. attorney to find out what they want done with that case, to find out how they see the case. And then you go talk to the lawyer. A friend of mine said most lawyers in New York only know how to do one thing. And that is, for a motion practice, they raise their hands and call a cab to go to the U.S. Attorney's office to turn their clients. This is not saying I don't want to make blanket statements. They're all too smart in this room to know that I'm meaning every lawyer, and they all do that. My own son is a lawyer, and he doesn't do that. But I'm saying that that's the atmosphere we operate in. I got a feedback here. Maybe I should move back a little. And in that atmosphere, the playing field we're on has gotten smaller and smaller, diminished by the government's demands on what we can do and what we can't do. So this is the reality in which we live. I just got an email yesterday from a friend of mine who was a kid I gave a job to because she was a new mother, had a nursing baby, and nobody would employ her as a lawyer. She's now at Harvard. She's teaching their clinical trial course, and she emailed to tell me about a lawyer in Vermont. A public defender who had gone into private work was defending a wife beater, a domestic violence case, and he was listened in on by the sheriff's department in the jail. He called his mother. He said, "My lawyer, Miss So-and-so, told me that if the witnesses don't show up, I'm going to go free." Now, this not terribly bright sheriff's department guy, upon hearing this, called the district attorney. The district attorney and local law enforcement got a warrant from a judge in Vermont to listen in on this lawyer's conversations, this young woman. And that not being enough, they then got a young detective, or a detective of some age, I don't know how old he was, but to call her up and pose as the missing witness. And to say to this young woman lawyer, you know, I'm worried. If I get subpoenaed, do I have to go to court? Could you tell me what I'm supposed to do? Can you? Well, to her credit, she absolutely answered with the right answers, which I think most lawyers would. She said, I can't give you advice. You're not my client. You have to call the district attorney and talk to him about this. And then she said, and furthermore, I can tell you as an officer of the court that if you get a subpoena to court, you have to obey it. Click. They admitted when they released the warrant and all the materials around this wiretap that they were trying to get her to say something which would be an obstruction of justice. And then they would have arrested her, and that would have been the end of her career. Now, I say, to go to this like any, I don't know how many of you have ever been in trouble. I don't know how many of you have ever had a lawyer. I don't know many of you are lawyers. But let me tell you, it's criminal defense law 1 that you tell your client from the get-go how the system works. That's how the system works. If the government doesn't produce witnesses, you go home. It's an accusatory system. It doesn't mean that you, the lawyer, are going to do anything to keep the lawyers from coming in. I mean, to keep the witnesses from coming in, whoops. But the fact of the matter is, this is something you tell clients from the very beginning so they understand the process. And that they would go after a young woman lawyer who's representing, she's not representing Jack the Ripper here, she's representing a guy in a domestic violence case. Not that that's not serious, it's serious. I did those cases when they were not called domestic violence, when they were called get her out of the courtroom kind of cases. But at any rate, such a minor case, such a minor thing to have, and yet this is what it led to, and it could have led to worse things. And so I say to you, the attack on lawyers is still happening. We see it still happening when the Assistant Secretary of Defense gets up there and says, if you're a corporate person and your lawyer is giving free lawyers to those people at Guantanamo, you better think about who ruined your bottom line in 2002. Hello? I thought that the World Trade Center was about the loss of human life, not about corporate bottom lines. But at any rate, this is what Mr. Stimpson said, and he urged people, corporate clients, to think twice and to warn their law firms that they didn't want them representing these Guantanamo guys. To their credit, not one firm has dropped the case or backed out, but you know, that's the kind of thing that has a certain venom that goes out there. And it has a thing where maybe not the lawyers that are working on Guantanamo, but the guys in the boardroom, the guys who are the managing partners, are going to say, well, maybe the next time we'll go with just your everyday murderer who's on death row. We'll do that, and we won't get involved in these contentious cases. So the attacks on lawyers are still happening. They happen, but lawyers do stand up to them. And I do want to just say to you that we should look at the Jose Padilla case as a really shining example of lawyering by public defenders in Miami, by people who were appointed to the case in New York, some of them personal friends of mine, of people who stood with that case. That's a New Yorkism, who stood with it, who stuck by that case and never were relentless in following up on it. You know, Padilla was arrested getting off a plane in Chicago. He was an ex-gang member who had converted to Islam. He was accused by Ashcroft of bringing in a dirty bomb into this country. He was spirited away. At first, he had no lawyers at all. He was held as a material witness. Finally, a judge in New York, after months and months and months of litigation, agreed that he had to have a lawyer. And then the government had the temerity to say, Judge, would you give us a few more months because we think we're getting to him? It's like, you know, you tap the guy with the cattle prod on the shoulder and say, hey, you know, what you're doing isn't right. And he says, just give me a few more minutes. I'm getting somewhere with this guy. It's exactly what the government said. And not to his credit, the judge did give them a few more months, and a few more months with appeals ended up being years, and Jose Padilla was held for over 3 years outside of counsel, and it was only when the Supreme Court was clearly going to grant their habeas corpus, a disappearing concept on our current landscape. That is, the lawyers had said, why are you holding this man? Tell us the reason he is being held. They could not answer that, so they quickly indicted him down in Miami. Not for a dirty bomb, but for some really arcane conspiracy theory. But why the lawyers were so spectacular, I would submit to you, was that when they were made privy to the torture that their client had undergone, privy by that I mean they saw videotapes of it. They saw the client, who they had known in New York very briefly as a very different person. They saw his reactions to things, that he could no longer do anything but what the government would want him to do, and instructed his lawyers, don't raise that issue, don't do that. He had been a severely damaged person. He was but a wisp of what he had been when they first knew him, and this came because he was for 3 years not knowing night and day, under constant bright lights. Whenever he was moved, he had earphones on, he had dark glasses over his eyes. He was sensorially deprived, and he was deprived, of course, of any kind of any company whatsoever. He was isolated completely. And so these lawyers, who had received all this torture material under seal, because the government certainly didn't want this getting out, they made a motion to the judge. And in making the motion to the judge, that is, asking for a legal solution to a problem that was legal in nature, they used all of the torture material as an exhibit. And of course, then it became part of the public record, and it could not be kept from the eyes of the public. And they went on, and I think this was a unique and creative lawyering, which is still out there, and which I can't say we anymore, because you know I am disbarred by reason of being found guilty. And I wrote to the judge and I said, you know, you can send me to jail for many years, but Nothing is as painful as going past a courthouse at 9 o'clock in the morning for me, seeing people going in and out, lawyers, defendants, court officers, judges, and not to be part of that anymore, to be removed from it, not able to be what I am, which is, I'd like to think, a defender. At any rate, these defense lawyers made a novel motion. They said basically, because our client has been tortured, he cannot aid in his own defense. He cannot help us to defend him. He cannot appreciate the gravity of what is being brought against him. He was tortured, and now that government which perpetrated the torture should not be permitted to bring these charges. The charges should be dismissed. This is different from going in, which we all do, and say, by reason of insanity, my client cannot participate in this trial. If the judge grants you that, then the client goes back to usually some kind of a mental hospital where the government continues to work on him to get him sane enough to go to trial, if you will. They felt that that was the last thing they would want for Padilla. He had had enough of the government working on him, and so they made this motion. They did lose this motion, I am sorry to say, but in the course of losing it, they certainly made it very clear to all of us what a lot of us have known to be going on in U.S. jails for a long, long time, and that is systematic torture, not done with the rubber hoses the way we used to see it in the old crime movies, but by isolation, by psychological techniques. And I now realize that part of the reason why my client, Sheikh Omar Abdel Rahman, was in such diminished condition when I saw him in May of 2000 was because he had had isolation under these SAMs, isolation, complete removal from any social back and forth of any kind, except with his lawyers once a week and his family once a month for 10 minutes. He was not permitted to talk to the guards. He was not permitted to go to the Friday services. He was completely isolated. And I must say, and I say this with some degree of shame, we didn't realize it. Ramsey and I and Abdeen Jabara, who also carried his case, we thought, well, isolation is very bad, but at least, nobody's stomping on him. There's no electrical cattle prods. We didn't realize how serious, and that this is actually now they feel worse torture than physical abuse, mental abuse. And I now see that that was what had happened to him, and it certainly did play a role. I'm not saying that I'm able to blame it all on, oh my gosh, I saw what they were doing to my client, so I made the press release, because that's not entirely where it was. Was part of it. I was committed to my client. I was not committed to his cause. I was committed to him. And that is another thing that they did at the trial. They blurred the edges between my politics and his politics, because he did speak out. He spoke out against America, the America that funded Hosni Mubarak, who tortured, the first stop on the torture route. When they pick up someone in one of these countries and they're bringing them to Guantanamo, first they torture and they stop. Egypt is the first stop. And I know it because we have done asylum cases where people from Amnesty have come in and Human Rights Watch and described the kind of torture that takes place in the Egyptian jails. So there's just no question in my mind that his fight, the Sheikh's fight, was with Egypt. He was someone who saw very clearly that the way to overturn Mubarak was through an Islamic revolution, and that then would be replaced by living under the Sharia Islamic law. That is what he wanted. That is what he worked for. He never had any intention of seditious acts toward the American government. Never. He actually was very naive. He really thought he could come here, preach against Mubarak, who you always see draped around one president or the other for the last 20 years, and that they would allow him to do that, that he could have a bully pulpit here in this country, that he could raise money and tell people what it was really like over there, and that they wouldn't come after him, but they come after him, they did. So, as I'm saying to you, all of this played a role in my making of the press release, but then as now I believed that it was the right thing to do, it was the right thing to do for him. They blurred our politics by saying, well, see, she speaks out against America. She says that the parts of America that are racist, that are sexist, that are part of the capitalist imperialism should be destroyed. And he says that too, so you see they are united. But you see, we weren't united. We had a spirited discussion about this and the means and how and where we were different. And I tell you, the man was absolutely charismatic and brilliant when I first knew him. The last time I saw him, he was greatly diminished. He was not the same person anymore. He was a hollow man at that point. But I came here also to thank everybody for writing letters. As I said a little while ago, a lot of the letters to the judge had postmarks from Portland. If you pick up a copy of the latest newsletter, just 3 of the letters are reproduced there, and they are typical of the letters that were sent in. Some are typical. One is very atypical, but 2 are typical. One is from my grandson, 14 years old. His name is Ernesto. Don't say it, don't ask. And Ernesto wrote to the judge, "Dear Judge, don't send my grandmother to jail. She is too old and too good." I said, it really says it all, doesn't it? Another letter, which is reproduced there, is from a client of mine that I had taken care of. And you know, in the criminal business, you get someone when he's 17, he's on probation, he does something else, he ends up going to state prison, he gets out of state prison, you work with him on the parole board, everything else, he ends up going back to jail. You have a lot of recidivism. This client of mine, Jimmy Delabella, had a lot of recidivism, had finally turned his life around, had gotten into a really good drug program, was discovered there by a professor at Farley Dickinson in New Jersey and given a full scholarship to college, and was doing straight A's in college when on 9/11 his mother was killed on the 102nd floor of the World Trade Center. Jimmy turned to me because I was the friendly, kind ear, and I have remained that up until today. Actually, I'm going to officiate at his wedding next summer. But Jimmy wrote a wonderful letter to the judge about those days and saying, how could this woman who offered such compassion in the face of that be considered a terrorist, Judge? That letter is in there too. But the most remarkable letter, and I hope everybody will take the time to read it, was from Joanne Harris. She was a deputy attorney general under Clinton, Janet Reno. She was in charge of the criminal department, or the criminal division, they call it. She wrote a letter to the judge and said, Judge, you're the last one who can right this terrible wrong, because this case was overcharged. This case should never have been brought. We wouldn't bring it when it happened in 2000, and they should never have brought it. And if you don't do something about it, it's going to send a terrible message to the bar. And her letter went on to describe the kind of merry band of lawyers of which I'm proud to say I'm a member, the lawyers who fight the political cases, who do it very often for no money at all, but who fight the case because it's the right thing to do. Michael Deutsch, who recently won a very wonderful case in Chicago that was brought against one of the Muslim charities and also against a person who was accused of materially aiding terrorism. Also Liz Fink, who was one of my lawyers. She was with the Attica brothers for 30 years after the rebellion at Attica State Prison. Not one of them ever went to jail, and she eventually got them a large monetary settlement from the state of New York. She stayed with it, though, for all those years. Is that Brenna's 2.5-year-old I'm hearing there? It is, okay. Welcome, little girl. And with all of this, I think the judge was truly pushed by the letters. He realized that he could stand up to the government when he had 1,000 citizens in this climate who would sit down and sign their name and address at the bottom of a letter, who weren't afraid to do that, who weren't afraid that the government would next have them on a list and there'd be some, black van pulling up in front of their house and loading them in. I think he was very impressed by the letters themselves. They were wonderful. We're trying to get a publisher to publish them, and I will use them as sort of a vehicle to tell my life story, because they go back to when I grew up in Queens and come forward to going to college in Michigan at what I must say was a conservative Bible college, amazingly, but it was educational. And little did I think in 1957 at Hope College that in the 60s I would be out there with this guy raising hell. Little did any of us think that the 60s were coming. And when we get discouraged, I just want to say that to everyone here. In 55, when they were rounding up communists for national security, we never thought the 60s were coming, but come they did. And so we have to think they're coming again. So I want to end by just saying thank you to everyone who wrote a letter. I thank you all for coming out tonight to hear about the update on the case. Michael Ratner of the Center this weekend, we were down in the Bay Area. We spoke on Mumia Abu Jamal. I just want to say the name out loud here. His case is at a final moment. He is really the last time. He is before the Third Circuit. They have narrowed the case down to only 4 issues. If he doesn't win on one of them, this governor will sign a death warrant, and he will be killed. This brilliant man who is as far, and if you hear all the evidence, and we listened to it all weekend down in the Bay Area, is an innocent man. You can start out saying, I'm against the death penalty, so they shouldn't kill him. And then you can say, and he never got a fair trial, he should get a new trial. You really end up saying, they got the wrong guy here. They got the wrong guy. So if we go on each of those levels, please keep Mumia in your agitation. Because when Michael Ratner said to me, well, what are you going to ask people to do now? You always ask them to write letters or to come to New York and go to court, or what are you going to ask now? And I guess I'm going to say I want you all to get out there and do what you do anyway, which is agitate, which is to keep up the fight. We have a groundswell going. We got a little grassroots thing going now. We haven't had it in a very long time, and God knows we need it. I would like to say that, the Freedom Socialists had a headline that said, the elections, the congressional elections, may well turn out to be Heartbreak Hotel. That we put such store that if we could elect representatives and give them a mandate, they would be brave enough to do something. Well, it doesn't look like it. It looks like it's business as usual. But that doesn't stop us. We have to agitate. I'm going to be at the Pentagon a week from Saturday. I'm going to speak out and give them whatever we give them. But that's the most important thing, to keep the movement going, to get it so that it's at a point where is mass enough that we cannot be ignored, where it costs them more to come after Lynne Stewart than it does to not come after her. That is the level it has to be brought to, and it has to be brought to on behalf of Muslims persecuted and railroaded into prison, and there's plenty of those we could name. And it has to happen on behalf of the old political prisoners, the prisoners that were arrested in San Francisco recently for a 30-year-old crime, confessions procured, not even confessions, information procured, torture, here we go again. And in my mind, that case is about legitimatizing testimony taken by torture. That's the next step. And if that can come in, there's no holds barred anymore. Then they can put anything in front of a jury and say, believe it. So there's lots of work to do out here, but I really think that the most important thing we can do is to keep on keeping on, as they used to say, and really make our voices heard, make ourselves an irritant, make the causes we champion, and we have different causes. My friend Dan here from the veterans, all of the causes that are out there that we can certainly bring to the forefront and try to educate our fellow Americans, to connect the dots, to see the imperial design, to understand that this is not happenstantial, that we got into a bad place in Iraq by accident, but to see this was the design. This is where we're at, and we're going to see a lot more of it. We're going to have a World War III in the Mideast. There's going to be a whole lot more deaths and a whole lot more young people dying over there, whether they're an army by choice or because they couldn't be anyplace else by economic reasons or race or immigration status. So there's lots to do, that's for sure. We are the grassroots, and agitate, resist. I cannot urge it more strongly. Thank you very much. Oh, I should read poetry. I should read some poetry. As an encore, I just want to quote first John Wooden, the great basketball coach, who is quoted as saying, it's what you learn after you know it all that counts. And that's what I do on these tours. I learn, after I know it all, what really counts. I'm going to read to you from Seamus Heaney. He's an Irish Nobel laureate. This is The Cure from Troy, and I think it really speaks to our time. Human beings suffer. They torture one another. They get hurt and get hard. No poem or play or song can fully right a wrong inflicted and endured. The innocent in jails beat on their bars together. A hunger striker's father stands in the graveyard dumb. The police widow in veils faints at the funeral home. History says, don't hope on this side of the grave. But then, once in a lifetime, the longed-for tidal wave of justice can rise up and hope and history rhyme. So hope for a great sea change on the far edge of revenge. Believe that a further shore is reachable from here. Believe in miracles and cures and healing wells. Call miracles self-healing, the utter self-revealing, double take of feeling. If there's fire on the mountain or lightning and storm, and a God speaks from the sky, that means that someone is hearing the outcry and the birth cry of new life at its term, that justice can rise up and hope and history rhyme. Thank you.